He came to Carolina from Stanley County, Moorhead Scholar, graduated playing football, captain of the football team in 1963, and then graduated from law school in 1967. Certainly one of the most outstanding students in our class. Roger has been honored over and over again in his professional career. He's a member of the Academy of Trial Lawyers, or the American College of Trial Lawyers, the American Academy of Appellate Lawyers. He's been listed in Best Lawyers in America since the first edition in 1983. Roger is a wonderful speaker, a person that I'm happy to say is my friend. Roger, come on up here. Talk to us.
Thank you, David. I'm honored to be here. I'm now 37 years gone from the law school that David has described, Manning Hall and the campus at Chapel Hill, the poplars and the big oaks, and the brick walkways laid down after the custom of the students, where they already had walked, just like the law is laid down after the custom of the people, where they already have walked. And 37 years gone from the inspiring spirits of people like Frank Porter Graham, Bill Friday, Bill Aycock, Al Lowenstein, Dixon Phillips, Dan Pollitt, and countless others of my heroes. Gone from Chapel Hill's Franklin Street boycotts, marches, protests, and surges of bodies and total traffic shutdowns that opened doors. And gone from the free speech movement, the talk-ins, the sit-ins, the lie-ins, and the be-ins. While the talk-ins, sit-ins, and lie-ins were the most politically, socially, and looking back, historically significant, the be-ins certainly seemed to be the most fun. I went with two law school classmates to my first and only be-in 1966 on the Carolina campus at the edge of Franklin Street, outside Graham Memorial Student Union, right there at the feet of Silent Sam. It was the spring of '66, and we were second-year law students. Three vanilla guys with short haircuts and khaki pants and neat shirts, sort of in the style of the Kingston Trio. We heard there was going to be a be-in over at Silent Sam, and so we took a break from the law books and strolled over to see what was happening. When we got there, we saw beads and flowers and sidewalk mushroom drawings in psychedelic chalk and funny little cigarettes, and people smoking dried banana peels. Men had ponytails. A woman arrived wearing no bra and a blouse made out of chicken wire. There was a big group of people gathered in a circle with a pink and blue blanket, and they were enthusiastically tossing giggling volunteers into the sky by quickly pulling the blanket taut and then catching the person as they came down. Everyone's favorite giggling volunteer for this blanket toss was a woman who expressed her freedom by wearing a short skirt and no underpants. These were laughing love children. And as we left the be-in and walked slowly back to the law school, I knew I'd been born too soon. Landing at the age of 25 on the downside cusp of a spring breezy social revolution in which the Stanley County and Puritan ideal that life is but a series of duties was overthrown in favor of Dr. Timothy Leary's and the Beatles' ideal that life is but a series of doobies. I'm 37 years gone from all that now, and I'm honored that at this time when my life often seems but a series of grandchildren and a procession of funerals for my mother, father, aunts, uncles, cousins, and friends. I'm honored I've been invited to come here and join Mr. Justice Orr, Joe Eason, and Dean Nichol to speak to this gathering of colleagues. And this gathering, like our gatherings on other nights and days, and like other gatherings of kindred spirits across the land, is hardly noticed by people outside these walls. And even to those of us here, today's gathering seems like those other gatherings, a routine professional event with CLE credit. But the truth is that our little congregation of colleagues at the bar is of surpassing importance to you and to me and to those beyond the walls who hardly notice. For this congregation is here for crucial communion, to drink from the well of collegiality, to draw strength, to be rough, robust, and resolute, to resolve again that we shall neither slumber nor sleep, falter nor fail in our determination to keep safe the rule of law, the Constitution. That Constitution, you know, does not keep we the people together. Despite those words about forming a more perfect union, we the people ordained and established the Constitution to keep ourselves apart. We don't need a three-part document to keep us together. We do that naturally. The tired, the poor, the wretched refuse, the homeless, the tempest-tossed were already passing through the golden door and were already huddling in masses by the time of the Constitution. The Lord only knows why we huddle as we do. We seem to be pulled or pressed together. Whatever the source of the gathering force, we exist in clumps, pairs, families, neighborhoods, clubs, associations, congregations, communities, towns, cities, troops, and all manner of other groups. Indeed, a solitary specimen of Homo sapiens is a rare sight, unless you just happen to glimpse the creature moving between groups. The corpse of a 5,000-year-old Austrian iceman lately lay frozen in state by the terminus of a glacier 2 miles high in a green alpine valley. The real riddle posed by his resurrection and appearance is this: what was he doing out there so far from his village, all alone? Heaven only knows why we cling together so. Of course, the benefits of pairing up suggest some seductively simple explanations. It does take at least two to be sexual, intimate, reproductive. And it takes at least two to divide labor, share guard duty, and spread the risk of injury and catastrophe. But the human propensity to come together is fueled by mysterious needs that surpass these yearnings for pleasure, posterity, and the synergy and comfort of group living. Gathering is not a routine convenience, but a strange necessity. In the setting of these ever-tightening and forever quarreling groups of people, we lawyers are the keepers of the rule of law. And so I want to talk to you about how we can take better care of the rule of law by taking better care of ourselves. And I want to do that by proposing 4 simple rules for taking care of ourselves and maintaining our professional effectiveness. Here then is my report. When I arrived in Raleigh from Chapel Hill in 1967, Fayetteville Street was a real street. stretching from the state capitol on Union Square down to the towering Greek columns of Memorial Auditorium. Much of the state's history had been played out on that street. In the very early morning of April 13, 1865, federal cavalry troops just at daybreak, coming back north from the burning of Atlanta and Columbia, entered Raleigh from the south, led by General Kilpatrick, and with banners and flags unfurled and a band playing, the troops marched right up Fayetteville Street to the state capitol. At 7:30 that morning, General William Tecumseh Sherman himself made his way up Fayetteville Street on horseback and set up his headquarters in the governor's palace. In more peaceful times, including the years when I began the practice of law in Raleigh in '67, great parades swept up the Grand Old Boulevard straight to the Capitol during inaugurations, holidays, and celebrations. In the mid-'70s, the street was turned into a pedestrian mall, and the hustle and bustle of earlier days, shoppers, taxis, automobiles, and the occasional conqueror, were replaced by a sanitized, signless expanse of expanse. The city mothers and fathers, I understand, are just now stirring themselves to restore the street. But back in 1967, Fayetteville Street was the real thing. And on the corner of Fayetteville and Davie Street stood the Durham Life Insurance Building, a sturdy, imposing structure designed by the same man who designed the Empire State Building. It was right next door to the Wake County Courthouse, and it still stands today as the Wake County Office Building. Downstairs on the first floor of that building was Honecker's, a coffee and sandwich shop, which featured small tables scattered out across a marble floor. The main wait person for as long as Honecker's was there was a woman named Esther. And the last I heard of Esther, she was still waiting tables downtown at Joe's Mom's Food. Lawyers and others gathered at Honecker's in mid-morning. Civil lawyers, criminal defense lawyers, DAs, insurance agents, to drink coffee, tell jokes, make fun of judges, and talk about the events of the day, sports, and anything else that came up. Criminal defense lawyers ordinarily would go to district court, answer the calendar, speak to the prosecutor, and go over to Honecker's for coffee. One morning in 1969 or 70, about the time of Woodstock, I went to district court, answered the calendar, spoke to the prosecutor, and invited my client to go over to Honecker's with me for coffee. My client and I sat at a table alone, just at the edge of, but away from, the usual gathering of lawyers. The next day, I was in the lobby on the third floor of the courthouse, and I saw my dear friend and mentor, Mr. Robert L. McMillan, who's seated right here, across the lobby. When Mr. McMillan saw me, he said, "Roger." "Yes, sir, Mr. McMillan." I always said yes, sir, because he referred cases to me fairly regularly. "Yes, sir, Mr. McMillan," I said. And he said, "Don't drink coffee with your client." I said, "Yes, sir, Mr. McMillan." And that's the first of the 4 rules. Don't drink coffee with your client. The rule simply means keep yourself physically and emotionally apart from your client. If you get too close and you care too much, there's a real danger of becoming ineffective and falling into improper conduct. Closeness can bring terror of the consequences your client is facing. You can become paralyzed and unable to act. Research is not done. It's too painful to pick up the file. It hurts too much to give the client bad news or even a realistic appraisal of the risks ahead, the odds for a terrible outcome. It hurts too much to communicate. It's easier to overpromise and give false hope. It took me about 15 years for all these aspects of Mr. McMillan's admonition, don't drink coffee with your client, to become clear to me. I was employed to represent a lawyer. He was in deep trouble for aiding a client in wrongdoing. Involved in this case, I worked with this lawyer for many months. We traveled back and forth to New York together. We ate together. We drank together. I admired, respected, liked, and enjoyed the company of this man. Ultimately, he was sentenced to federal prison and was allowed to self-report. We bought 2 airline tickets, one round trip for me and one way for him, and flew to the airport near this prison, took a taxi to the prison gate. I walked him to the prison gate. I was introduced to the warden. The warden did me the great good service of allowing me to go in and examine the room, the cubicle where my client would be staying. I left this man at the prison gate in tears, flew back to Raleigh, and after that, I was paralyzed for about a year and did not know why. I finally learned through suffering and through the expenditure of large sums of money on counseling the real meaning and importance of the rule, don't drink coffee with your client. This is a somewhat controversial concept. There are those who would suggest that you do a better job if you become friends with your client. Indeed, another lawyer who got himself into trouble with the law later ventured to say that he believed friendship was essential to effective lawyering. If I were a licensed attorney today, he has written, I would get to know my client on a personal level as well as on a professional level. Upon reading this statement, another Raleigh lawyer was moved to write, he has made me think about how I can better represent my clients. If I resolve to know personally each of my clients, I can give them my best legal representation. I know and respect both those men, but that's poor advice. Keep your distance from your clients. For years, when conferring with a client, and I like to use easel charts in my office, it helps me keep up with what I'm saying, and it helps them visually follow what we're talking about. And I would stand in front of that and I would say, the charges we're facing here are these. Now, our position about this matter is this. Our court date is November the 14th. Now, struggling to be somewhat wiser, I consciously refer to, you are charged in this case with, your position in this case is, and you have to be in court on November the 14th. And I can assure you, despite my instincts, that I don't go with anyone to report to the prison gate. This rule does not mean that you should not try to understand your clients as whole persons and to help them deal with all their needs. It means do not become emotionally involved and swept away. One way to think about this is in the traditional sense of what it means to be a professional. Being a professional means, among many other things, doing your work for a living. I recall a momentous trial in which my brother Wade and I were representing a man in a county in the mountains of North Carolina. We were staying at a motel several miles from the courthouse. Tried the case for about a week and a half. Ended the evidence at the end of the day, and it fell to me to make the closing argument. I don't know how it fell to me to make the closing argument. I think I just did not speak quickly enough. But it fell to me to make the closing argument. And so that night, I stayed up all night in my motel room, sifting through the evidence one more time, gathering my thoughts, preparing my delivery, pacing that room, giving my argument. By morning, I was primed and ready to go, totally focused, in a zone, operating on adrenaline and a bundle of nerves. My brother calmly suggested that we leave early for the courthouse so we could drive by our client's motel, which was downtown, and meet with him and his family before court. So off we went. And as we neared the motel where the client was staying, I balked. And I explained that I was too wound up by my assignment of giving this closing argument to bring comfort, peace, and reassurance to the client. As far as I was concerned, and I said it, the client ought to be bringing comfort, peace, and reassurance to me. Bless Wade's heart. He pulled the car over on the shoulder of the road and looked at me and said, "Wait a minute. We do this for a living. This is how we're sending our children to college. This is the client's case, not our case. We're not in trouble. Our client's in trouble." So we stopped by the client's motel, had a brief visit, and went on to the courthouse. I made a great, impassioned, well-reasoned, logical argument to the jury, which promptly retired and returned verdicts of guilty as charged on all counts. And I learned a lot that day about what it means to be a professional. Remember that Dr. Sigmund Freud had his patients lie on a couch during psychotherapy. This was not for the benefit of the patient, as one might guess. It was so Dr. Freud would not have to look the patient in the eye. For Dr. Freud to do that would have been for him to risk connecting with the patient on a personal, emotional level, drowning in the patient's pain, losing his objectivity, and becoming ineffective as a therapist. So be a professional. Keep yourself physically and emotionally separate from your client. Remember rule 1. Don't drink coffee with your client. I can't go back to Honeckers. It's long gone now. It disappeared in the late 70s, not long after Fayetteville Street became a mall. But if I could go back to Honeckers today, I would not drink coffee with my client. Instead, I would abide by the real wisdom of Honeckers. I'd drink coffee with my colleagues. Because I assure you, if I had the opportunity to learn from my mistakes by reliving the times I made them, I would take advantage of the opportunity. But there are just so many things one does not have a second chance to do. In fact, it sometimes seems like the most important things one does are things that there's only one chance to do. So you can't do those things better the second time because there's no second time to do them. And this principle that we need to try and get it right the first time is the essence of the reason for the second rule. Lesson 2 from Honecker's Coffee Shop: drink coffee with your colleagues. One of the most difficult aspects of lawyering is that of knowing whether you're doing okay. There's lots of art and not much science to the practice of law. There are countless ways to examine a witness, make an argument, try a case. If we ask 100 artists to paint a picture of the state capitol, and we arrayed them around Union Square on that sidewalk with their easels, they would produce 100 remarkably different renditions. And if you took the same criminal case to 100 different criminal trial lawyers, they would adopt 100 different theories, design countless ways to examine the witnesses, and argue to the jury. Since there's no right or wrong way to do much of what we do, it's difficult to know whether you're doing okay. There's not much feedback. In that setting, it's easy to get lost and expect too much of oneself. If we have unreasonable expectations, it's easy to cheat just a little. Get the client to change one little fact. Drinking coffee with your colleagues helps you avoid getting lost in unrealistic expectations. Communing with our colleagues helps us stay in touch with reality. Are you not winning any DWIs where the alcohol reading is 0.10% or higher? Go drink coffee with your colleagues and learn no one else is winning any of those cases either. Are Judge Manning and Judge Stevens giving you hell? Go drink coffee with your colleagues and learn they're giving everybody hell. You don't know what to say on behalf of the poor fellow who has never had an honest job and has been immersed in crime all his life? Go to coffee and learn that you can say, Your Honor, he has a wonderful mother. And if he doesn't have a wonderful mother, go to coffee and learn that you can say, as Mr. McMillan told me, he heard a lawyer argue one time, Your Honor, I understand that when his mother was a young woman, she was a great whistler. On my office wall are a series of 19th century woodcuts by Daumier depicting moments in lawyers' lives. One of my favorites shows a lawyer in court extolling the virtues of a downtrodden, hapless wrongdoer, and it's entitled, A Respected Citizen. Another shows the lawyer referring to a poor unfortunate as this saintly woman. The point is that the things with which we 21st century lawyers struggle are the same things with which our professional ancestors have struggled for hundreds of years. How does the evidence look? How do we chart the client's course through the rocks and shoals of these troubled waters? What is the best theory of this case? Should we go to trial or settle? How do I try this case effectively full out without revealing secrets which the client fears more than the criminal charges? How does one cross-examine a crying child? How do I object to testimony and retain my position as a truth seeker? Should the defendant testify? How do I keep reasonable doubt alive in the face of 5 disinterested witnesses? How do I persuade the jury to turn a verdict of life instead of death? What do I really say on behalf of the poor defendant who has never had an honest job and been immersed in crime all his life? The difficulty of resolving these questions can leave one with doubts about one's ability and sanity. You can find yourself thinking, as the great Wyoming lawyer Jerry Spence says he thinks every day, I wonder what a real lawyer would do with this case. You can mitigate these confidence-robbing self-doubts by taking comfort in the knowledge that many lawyer decisions simply are agonizingly, inherently difficult for all lawyers. And you gain this knowledge from other lawyers. Commune with your profession. Talk with your colleagues. And stay in touch with reality. A lawyer isolated from the profession is far more likely to run afoul of the rules of professional conduct. About 3 years out of law school, I represented a man who was charged with common law robbery. He was facing a maximum of 10 years in prison. He had no prior record, and he and his family were hoping for probation, and I thought that that was a realistic hope. Standing before Superior Court Judge Leo Carr, I made my best sentencing argument. pointing out every helpful thing I could. Probably even talked about the goodness of this man's mother. And after I finished pouring my heart out, Judge Carr calmly sentenced the man to 9 years in prison, one less than the maximum. The client cried, his family cried. They were sad and bitter and angry with me. And I cried. In those days, I expected too much of myself and took it all to heart. After watching the bailiff lead my client away to prison in handcuffs and finally seeing the family to the courthouse door, I made my way over to Honecker's coffee shop. And when I walked in, the lawyers gave me a standing ovation. "You saved that man a year of his life," they said. I love lawyers, especially criminal trial lawyers. They define victory and success in especially realistic ways. Your friends in the bar will share their realistic definitions of victory and success with you if you give them a chance. Commune with your profession. And that is rule 2. Drink coffee with your colleagues. In 1967, after I graduated from law school and passed the bar, I moved my family to Raleigh and began working as a law clerk for Justice Carlisle Higgins on the North Carolina Supreme Court. I greatly enjoyed my year with the court and learned a lot. After that clerkship, I went 3 blocks down the street to the Durham Life Insurance Building and joined my brother Wade and his law school friend Harold Tharrington at the firm they had founded 3 years earlier and began the private practice of law. As I became involved as an advocate in real cases, I was startled to begin to absorb fully the human realities of the conflicts we lawyers undertake to resolve. I knew from law school, of course, that the law addresses conflicts between and among people. After all, for 3 years, I'd been immersed in the world of versus, A versus B, B versus C, C versus D, and so on. But all that law school bombardment of this versus that gave me no appreciation for the real world truth that all the fascinating legal questions we had kicked around and debated and been quizzed about in law school arise in the complex lives of flesh and blood people. Our clients, even corporate president clients, feel anger and love and hate and sadness. They bleed and hurt and cry and rant and rave. So do their families and friends. So do their adversaries. In criminal cases where much of the defendant's life may be on the line, the defendant and the defendant's family are in excruciating pain and under unbearable stress. And the victims and their families bleed and hurt and cry, and sometimes so do the courtroom clerks, so do the jurors, and so do the bailiffs. A lawyer who plunges into that emotional quagmire needs to go in with a secure personal identity of his or her own. Otherwise, the blood and hurt and tears of the parties and the witnesses and the forum become the blood and hurt and tears of the lawyer. And that brings me to rule 3. Drink coffee alone. This rule simply means that we must spend some time tending to our own personal selves. A lawyer who loses his or her own identity in that of the client or the cause becomes ineffective and is a real candidate for professional wrongdoing. After all, if you're carrying the banner of righteousness and are truly on the side of the angels, lying and cheating really become pretty easy. It's crucial, therefore, to spend time just with yourself, look at yourself, understand yourself, what's important to you, and be aware of what you are doing. Put yourself in context. A few years ago, I had the honor of standing here and speaking upon the occasion of my brother Wade's receiving the Chief Justice Joseph Branch Professionalism Award from the Wake County Bar, just as Ed Gaskins did today. It was a tough assignment for me because I love him about 51% and resent him about 49%. But nonetheless, I turned my attention to the job and decided to take a look at how he functions day to day. And one of the things I discovered about Wade is what a clear view he has of his place in the world. He does so many things so naturally and easily because he lives, moves, and has his being on the firm, rich soil of an abiding spiritual and philosophical perspective on life and the law. That is, while he does a lot of things, he spends more time thinking and reflecting about the things he is doing than he spends in actually doing those things. Feelings of self-worth come from within, not from success without, in the law or otherwise. A person who expects to find basic self-worth from success in lawyering, particularly criminal lawyering, is going to be disappointed. Coach Dean Smith has said, if you make every game a life or death proposition, you're going to have problems. For one thing, you're going to be dead a lot. And so it is with our cases. If you make every case a life and death proposition, you're going to have problems. For one thing, you're going to be dead a lot. In terms of success, the practice of criminal law is like playing baseball. The best hitters in the world fail 7 out of 10 times they go to the plate. And the best criminal lawyers in the world fail 7 out of 10 times they go to the plate. A legal career is a long-term proposition. Perspective is crucial if we are to cast enduring light across the profession and not be merely a shooting star, brilliant, but only for a moment. That is rule 3. Drink coffee alone. And finally, when the courthouse closes and day goes down to dark and Honecker's coffee shop locks the door and pulls down the shades, go find some folks to share the night. And that's rule 4. Drink wine with your loved ones. The rule simply means you should tend to the important relationships in your life. Our need for others fades quickly from conscious thought and melts away in the face of the day-to-day world of preparing, meeting deadlines, and trying cases. That need for others, however, is a basic part of the human condition. If a lawyer ignores loving and caring relationships and decides to go it alone, his or her ability to make sound judgments based on genuine feelings suffers. The lawyer gets hurt, so do the clients, the processes of the court, and the legal profession. For the first 15 years of my practice, I went wide open. The only limit I had on how long I would spend preparing for trial was the number of hours available between now and whenever the trial starts. I suffered, my wife suffered, my children suffered, and still suffer from the effects of my absence. In those years, I can remember seeing Mr. McMillan in the courthouse. He would say, "Roger, you look worn out. Stop this staying up all night. In 5 years, you won't even remember the name of this client you stayed up all night for." But I soldiered on. I don't do that anymore, and I urge you not to. Don't be put off by the fear that you may come up short if you don't sacrifice your personal life on the altar of your case of the moment. Lawyering is about living. You won't be very good at lawyering if you are too immersed in work or too exhausted from work to experience life, fully involved with people who are important to you. No less an achiever than Wolfgang Amadeus Mozart observed, "Neither a lofty degree of intelligence, nor imagination, nor both together go to the making of genius. Love, 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 that is the soul of genius." So, do not isolate yourself from people. Let there always be people in your life who matter to you beyond measure, and spend time with them. And that's the fourth and final rule: drink wine with your loved ones. Every day across this land, people live out their personal lives, having their beliefs, thinking their thoughts, assembling, complaining, being private, and keeping secret. And every day across this land, those people submit their disputes to the majestic workings of the rule of law. I see these folks in the morning climbing the broad steps to the courthouse. Victims, complainants, plaintiffs, defendants, witnesses, and their families and friends, angry, hurt, anxious, and frightened. I see them in the courtroom at adjacent tables, scant inches away from each other, accused and accuser, squared off, awash in the proclamations, prayers, and pleas, their loved ones looking on from the congregation, friends of the one party over here and friends of the other party over there. During recess, I see them in the coffee shop, waiting in line to pay, side by side, grim-faced, and studiously avoiding eye contact. At the end of the day, I see them leave, descending the broad steps, the vanquished and the victorious. And sometimes then, outside at the foot of the steps, I sense their boiling rage, see their icy stares, hear their hot taunts and cold curses, and catch my breath while they make fists and hiss threats. Then I'm struck by how near we always are to fighting in the street. How tentative is the calm, how uneasy the peace, how fragile the truce. But almost always the rage cools, and the disputants leave the street and head for home, the losers to brood late into the night, and the winners to sleep the peaceful sleep of the court-certified righteous. Sometimes, looking back across the day from night, when everything has worked just right, the whole courthouse exercise looks and feels as if it could have been a religious service. It is a miracle that in this land, living out our tumultuous lives of glory and mystery, we simultaneously keep our communion, preserve our separate selves, and give wing to our soaring spirits. And it is a miracle presided over by lawyers. So, by way of review, Rule 1, don't drink coffee with your client. Rule 2, drink coffee with your colleagues. Rule 3, drink coffee alone. Rule 4, drink wine with your loved ones. Life for me has been about 10 times as difficult as I thought it would be when I was 20 years old. Practicing law has only been about 5 times as difficult as I thought it would be. It's not the intellectual side of living and lawyering that is so hard. It's the personal, emotional side. Keep your distance from the people involved in your cases. Stay in touch with your colleagues. Take care of yourself. And give attention to the important relationships in your life. Thank you.
Thank you all for coming out to this CLE today. One of the great tests of a good CLE is whether it touches each and every one of us. And I can tell you that when you listen to Roger Smith, he touches our soul. And I thank you, Roger, for your presentation. Our next speaker is Justice Robert F. Orr, who was born in Virginia, but grew up in Hendersonville, North Carolina, before he went to Chapel Hill, where he graduated from undergraduate school, served in the Army for several years before coming back to get his JD at UNC in well, I don't know what year he graduated, but he did graduate and then went back to Asheville to practice law before he was appointed in 1986 to the Court of Appeals, and before he was elected in 1994 to the North Carolina Supreme Court. Everyone is aware that in March of this year, he announced that he would be resigning from the court to take the position as the executive director of the North Carolina Institute for Constitutional Law, where he has served since that time. An avid softball and baseball advocate, we welcome him to our program today, Justice Orr.
Thank you, David. No one should ever have to follow Roger Smith in giving any kind of presentation, and having spent literally 18 years giving bland, nonsensical speeches as a part of the judiciary. It's a challenge to come here today, and it's particularly unnerving to think that Gene Nichol will have the last word in all of this. And since he's not here, maybe he won't show. I don't know. Roger, I very much appreciate and take to heart those words. I think they were splendid. It's been 18 years since I had a client, but I think I clearly violated the first rule of not drinking coffee with clients. Not only did I drink coffee with clients, I think I ended up paying for the coffee with the clients. Anyway, it's a treat for me to be here, and I appreciate very much the opportunity to address this CLE program on the topic of civility, or perhaps the lack thereof, an increasing challenge to professionalism. In contemplating what I should say in my allotted time, my internal debate centered on whether I should sort of fill my remarks with what I would consider bland commentary and pithy quotes and a few stories, most of which would simply boil down to telling you that in regard to the topic of civility, Mama said we should all play nice. On the other hand, I question whether I should jump into a more controversial, sensitive discussion of real-life events and see how well we do match up with our creed of professionalism. Somehow it just didn't seem to be a beneficial use of yours or my time to take the cautious approach, and so now, having had my First Amendment rights of free speech restored to me upon my retirement as a judge, I feel the need to plunge ahead and evaluate whether this creed is anything more than just a useless recitation of beliefs that nobody really believes in or practices, or whether it really means something to us. It's appropriate that our discussion today on this topic falls on November 2nd, Election Day. Having been bombarded by a battery of political commercials that shade the truth, focus on the irrelevant, attack the motives and intentions of good people, and generally give the political process a bad name, we acknowledge the obvious. We are a polarized society. We are divided into red and blue states, conservatives and liberals, rich and poor, black and white, Asian and Hispanic, gay and straight, and just about every other way imaginable. And those who are not in your group, at least if you believe the ads, are unpatriotic, despicable, uncaring, venal, lying, cheating, stealing scoundrels that should be ridden out of town on the proverbial rail. The only thing civil about our political system is perhaps the civil litigation that may very well come out of this election cycle. So should it come as any surprise to us that there is an increasing uneasiness that this lack of civility can also be found in the profession of law, where the same winner-take-all mentality and gunslinger attitude can approach what we see in our political system. After all, lawyers are in many ways the key players in the political system, and the lessons learned in one field clearly translate into the other. Mama may have told us to play nicely, but what we've learned from watching society in action over the last 40 years seems to tell us otherwise. In your face is more than a slang expression. It is the embodiment of much of what we learn and our children learn from watching television and the movies and the actions of our athletic and cultural heroes. Just as those in the public eye tend to reflect society, so do we as members of the legal profession. Perhaps the one difference is that we as a profession recognize that despite the sometimes rough and tumbled existence of lawyering, we aspire to be better than a reflection of society in general. We aspire to be professional and to demonstrate the trait of civility that society often ignores. But do we really care? Are we really willing to restrain our passions and our prejudices in order to try and meet that goal? Well, let's see if we can address those questions by taking what I would consider a painful and candid look at the events of the past several weeks regarding the David Hoke-Deborah Graves matter before the North Carolina State Bar. To say we are a polarized bar would perhaps be a slight overstatement. But is there any doubt that we are, at least to some extent, divided between the plaintiff's bar and the defense insurance bar, between the criminal defense bar and the prosecutorial bar, between small firms and big firms, between judges and the rest of us? The paragraphs of the 10th Judicial District Bar's Creed of Professionalism that I would like to focus on call on each of us to make certain pledges to certain entities. And the first is a pledge to your colleagues in the practice of law, to whom you offer your concern for their welfare, and in doing so promise, as you work together, to respect their personal and family commitments and share your learning and experience so that we may all improve our skills and abilities. Well, let's take a look at one of your colleagues in the 10th Judicial District Bar who was at the center of an unprecedented meeting of the North Carolina State Bar Council on October 20th. The only colleague there on that specific day and on the specific hot seat was David Johnson, a veteran lawyer who represents the North Carolina State Bar in prosecuting complaints against attorneys charged with a violation of the rules of professional conduct. While I don't know Mr. Johnson personally, he is by all observations an experienced, diligent attorney who was assigned the task of prosecuting the charges against David Hoke and Deborah Graves. He did so with the full authority and responsibility of the State Bar. There were several hundred lawyers in the room for the meeting of the council, but I think less than a half dozen who had actually sat through the prosecution and observed personally Mr. Johnson present the case. In the end, Mr. Johnson was successful in the prosecution and argued vigorously for a more serious punishment than was meted out. The disciplinary hearing committee, appointed by Rick Gammons, a member of this bar, instead chose to impose a reprimand. At this meeting, through a variety of questions and statements by members of the council, Mr. Johnson's handling of the case was second-guessed over and over. Now, we all enjoy Monday morning quarterbacking, and I dare say many of you have replayed a few trials of your own and concluded that perhaps there was a better way of handling the case or wishing that you had done something differently. But how appropriate is it to second-guess the handling of a case when you weren't there to observe it firsthand, and you don't have a full knowledge of the material the lawyer had, and then to do that second-guessing in a public forum with the press hanging on every word? Most troubling, however, to me, was the indirect and at times almost direct intimation that the prosecution of the case had been tainted by some outside influence, and that, in effect, Mr. Johnson had tanked the case. Your colleague stood before a primarily hostile audience and was forced to publicly defend his honor, his professionalism, and his integrity before an audience that often laughed derisively at his answers and hissed audibly at points they disagreed with, or, as the News and Observer described it, a chorus of snorts and giggles. To this colleague of yours in the practice of law, little, if any, concern was expressed for his welfare or the concept of civility, all of which seemed lost in the process. The two other members of the 10th Judicial District Bar who were at the center of the council's meeting were not present. But these colleagues of yours were certainly the focus of everyone's attention. Well, who exactly are Deborah Graves and David Hoke? By all accounts, by all who know them, here's what the record would show. Deborah is an African-American woman who's clerked at the Court of Appeals, taught at North Carolina Central School of Law, worked for the Attorney General, and now is with the Federal Public Defender's Office. As former Judge Charles Beckton said about Deborah at the disciplinary hearing, she is an honest, skilled attorney with the highest standards of professionalism, a person admired and respected by Judge Beckton and others who know her and have worked with her. She's also a youth basketball coach and active in other community activities. And David Hoke, he is a dedicated, bright, kind individual who also has been involved with a number of community activities through his church and civic groups. He's married and the father of a young daughter. He's clerked at the Court of Appeals for Chief Judge John Martin, who described David as a fine lawyer and friend. He's worked for the Attorney General's office and for the past 3 years has been the Assistant Director of the Administrative Office of the Courts. Personally, I've known both of these individuals for over 10 years and consider them friends and colleagues in whom I have absolute confidence in their integrity and commitment to professionalism. But like most lawyers I know, including myself, they are not perfect in always carrying out their duties. They make mistakes like the rest of us. And as a result of the mistakes made in the original prosecution of Alan Gell, they have been pillared in the press and in the bar, subjected to accusations of intentional misconduct and impropriety, and had their names and reputations besmirched by media accounts for over 2 years, and it hasn't stopped yet. Now, it should be noted for all of those who have surmised or speculated that their conduct was somehow intentional, that if you step back and actually review the circumstances, it is more than highly unlikely that this conduct was nothing more than a mistake, a point conceded by the State Bar and for which no contrary evidence is present. To think otherwise would require a conclusion that two relatively inexperienced capital prosecutors trying a murder case in a remote part of eastern North Carolina with a less than sympathetic victim decided to flagrantly disobey a Superior Court judge's order and intentionally decide not to hand over the statements in question, knowing not only that the local district attorney would be aware of those statements, but then that they would leave them in the file for post-conviction counsel. What in fact does the record reflect as to their actual failings in the original prosecution of the Gell case? And I'm not going to take a lot of time on this, but I think it's important to set the record straight. First is their failure to turn over to the defense approximately 6 or 8 statements of witnesses, I don't remember the exact number, who had been interviewed several years prior to the trial by the SBI. And pursuant to a Brady motion, these were not turned over in their entirety. The record shows, and is uncontradicted by any evidence that I'm aware of, that both David Hoke and Deborah Graves turned to the senior SBI agent assigned to the case, who had been involved in the original investigation, and said, "Get us those statements that the judge has asked for." Some were produced, some weren't, but on both occasions, the record reflects the SBI agent assured them these are all the statements. Now, the State Bar says that is an ethical violation because they failed to adequately supervise the agent. So be it. But I would suggest, how many of you as lead counsel have turned to an associate or a paralegal or an investigator and said, "Go get that information for me"? It may very well be a mistake not to do it yourself, or to not know what in fact was in the file. But I question whether a good faith reliance on a non-lawyer associate to comply with your request is an ethical violation, but the State Bar said it was, and thus it is. The second violation arose out of the failure to turn over a transcript and record of a secretly taped conversation between one of the young women who was the suspect and her boyfriend. In the conversation, the young woman talked in part about needing to get her story straight. The statement was, in the opinion of Hoke and Graves and Jim Coleman of the Attorney General's office, not required to be turned over under Brady. On the Marr motion several years later, the trial judge disagreed and determined that it should have been turned over. That decision, which resulted in Gell's conviction being set aside, was not appealed. Whether that recording and transcript constituted Brady material or impeachable material that should be turned over was vigorously disputed. Hoke and Graves and the Attorney General's office said it wasn't. Gell's attorney, the trial judge, and most defense lawyers say it was. My personal opinion, having reviewed the transcript, was that it was not material that would have been required to be turned over. Maybe I'm wrong. Maybe the AG's office and Hoke and Graves are wrong. If so, what you have is an incorrect view of the law. Was the decision to not turn over the tape and transcript intentional? Absolutely. Just like every single Brady issue that I reviewed over 18 years as an appellate judge, there was a decision by the prosecutor that it was not Brady material, and thus the issue came up ultimately on appeal. But I confess this is the only time that I am aware of a prosecutor being disciplined over a Brady decision when an appellate court has determined that it was incorrectly withheld as a matter of law. So what's the point of all this, okay? It's simply to set the stage for considering the extraordinary response by at least a portion of the bar to the discipline meted out to these two individuals and the process that took place. While the State Bar's meeting to discuss the case was unprecedented, what I find unprecedented is the cry of certain other lawyers that Hoke and Graves weren't punished enough. Over nearly 30 years as a licensed attorney, of which 18 have been spent here in Raleigh on the Court of Appeals and the Supreme Court, I cannot recall any situation where the bar has gathered and called for greater punishment against one of their colleagues. Now, lawyers from around the state and in this judicial district, as we all know, have frequently run afoul of the rules of professional conduct, from stealing from client trust accounts to improper sexual advances to clients, to publicly unacceptable conduct, to other types of criminal acts. Discipline has been imposed, and while I suspect that occasionally there was some mumbling about the penalty, never, that I'm aware of, has there been the cry of punish them more, particularly in an orchestrated fashion, for whatever failings they might have or done in regard to the Gell case. Why is it that Deborah Graves and David Hoke have been singled out by their colleagues at the bar and by the press as the focal point of whatever failings the system may have? In 9 days, on November 11th, Frank Chandler is scheduled to be executed for murder. Among the issues pertaining to his case are prosecutorial misconduct, withholding of Brady material, grossly ineffective assistance of counsel, and other issues. Yet I have heard no outcry or even a whimper from the press or concerned citizens or members of the bar who have figuratively brought out the rail, feathers, and tar brushes for Deborah Graves and David Hoke. Where is our concern about their welfare? The second pledge that your code of professionalism requires is to the courts and to those who assist them, I offer respect, candor, and courtesy. I will respect and strive to improve the judicial process. I will serve as an officer of the court, encouraging respect for the law and avoiding the abuse or misuse of the law, its procedures, its participants, and its processes. While the State Bar and Disciplinary Hearing Commission are not technically courts, they are the legislatively created organization of our profession and charged with the responsibility of disciplining the profession among many other responsibilities. Thus, when it comes to respect for the law and for our profession, no other organization can be looked to by the public or the profession. Now, while there were those who felt that the State Bar should not have had this so-called unprecedented meeting to discuss the prosecution of the Hoke Graves matter, the leadership chose to do so out of good faith and in an effort to inform the public and the bar about the proceedings because of the controversy stirred up by the media and certain members of the profession. As a result, the State Bar officials and Attorney Johnson were at best received with suspicion, derision, and a lack of courtesy and civility. At worst, there were quotes, one from a faculty member of the UNC School of Law and several others from attorneys, literally accusing the State Bar of a whitewash. And I quote that word. If we are supposed to foster respect, candor, and courtesy for our legal institutions, then unfounded allegations such as those are an abysmal failure to honor that commitment. If, in fact, a licensed member of our profession is going to claim that the process was a whitewash, then step forward with your evidence. If leaders of our State Bar have violated their oaths, then disciplinary proceedings against them should be filed by those who claim such a breach of duty. Otherwise, we as a profession fall victim to the controversial soundbite of political advertising and plunge our profession further into the morass of cheap shots, rumors, and innuendos with guilt by association. I find the entire story surrounding the Alan Gell case troubling, as do many others, perhaps for different reasons and some of the same reasons. But whatever the failings of the criminal justice system in our state, whatever the reasons for or against capital punishment, whatever the imperfect conduct of practicing lawyers and the State Bar's reaction and response to it, we all need to take a deep breath and step back before we plunge our profession even further into the polarized antagonisms of contemporary society. All the enormous good that can be accomplished through the legal system, all the confidence that we so desperately need and want the public to have in the system, and all the need for us in the profession to treat each other and our institutions with the respect and the civility that the 10th District's creed embodies is ultimately cast away if we allow our passions, prejudices, and angers to rule the day at the very expense of the profession that is ours. I wanted to close with maybe one small example, and I struggled to come up with a good one, and I don't know whether this is or not. I just finished reading David McCullough's book about John Adams, and I thought it was remarkable if you put in context the inability of Hamilton and Burr to resolve their conflicts, resulting in Hamilton's death, and the ability of Adams and Jefferson, who had been colleagues from the beginning of the creation of our country, but over the years had developed through the political wars and battles hard feelings against each other and their positions. How in the end of their life they came together, exchanged correspondence in friendship and mutuality of respect. And I think perhaps that embodies what we all should aspire to do despite the differences we may have. I close with a quote from a most appropriate source, Ed Gaskins, who earlier today said from this lectern, and I quote, "If we demean one of us in the public perception, we demean all of us." Thank you very much.
Thank you, Justice Orr, for your thought-provoking presentation. I think that should challenge each of us and incorporates our creed of professionalism and puts it in focus for all of us. Let's take about a 10-minute break. We've got two more speakers. We want to finish as close to 4:15 this afternoon as we can. We'll call you back, but about 10 minutes. While these folks are getting a drink and some food, let me just make a few remarks about this program today, which was put together by Carlin Poole and her committee, Bob Glotz, and a number of other people who were members of a subcommittee of the Professionalism Committee. A committee which I'm pleased to have chaired for the last 4 or 5 years, a committee which in the last 4 or 5 years has grown so that typically now we have as many as 40 people at our quarterly meetings. It's so impressive, in fact, that we this year divided it into 3 subcommittees. This is our first venture into a CLE program. I think it's been wonderful. I think it's going to continue to be very good as we get on with our 2 final speakers for today. Let me tell you about the handout. It's certainly not a traditional handout as we have with many CLE presentations. The first section of the handout is the Creed of Professionalism of the North Carolina Wake County 10th Judicial District Bar. Justice Orr spoke to our creed and of our creed. The next section, number 2, is Motivated by Service or Inspired by Profit, which was prepared, written by Joe Eason, the Wake County Creed of Professionalism and its relevance to fee disputes. Section 3 is a section on evolution of professionalism. I think as you look through it, you can see the developments in the area of professionalism for the last 60 or 70 years in North Carolina. And finally, the 4th section is professionalism and ethics. I want to next introduce Joe Eason. who'd been an attorney in Raleigh for the last 25 years or so. Joe is currently a partner with Nelson, Mullins, Riley, and Scarborough. Those of you who have known Joe for some period of time know that before that he was with Moore and Van Allen downtown. Joe practices with the Raleigh office of Nelson Mullins, focusing on the resolution of commercial and regulatory disputes with particular emphasis on utility and insurance industry issues. He also works in some other areas, related areas. He serves as chairman of the Fee Arbitration Committee of our 10th Judicial District Bar. He graduated from UNC Chapel Hill in 1977 with honors from the law school. Graduated from UNC Chapel Hill for undergraduate school as well. Joe, please come and make your presentation.
Thank you, David, and thank you for all of you for attending this afternoon. Obviously, the topic which I was asked to present with respect to fee disputes is not likely to lead to the inspiration of such as that you've got with Roger's comments or the insights and thoughtfulness of Judge Orr's, but it may potentially affect you in your private practice or from daily performance of your practice, regardless of what form that might take. Now, when I first learned I had volunteered to make this presentation, it sort of was perplexing to me that how professionalism and fee disputes would be integrated and try to present to a group that would probably be as or more familiar than myself with some of these topics. But as I thought about it, it occurred to me that it wasn't really a stretch at all. In fact, from coming from where I do, with, if you will, a more commercial orientation of practice, I had learned long ago that the law and the culture before it, from which the law sprung, had differentiated between professions, the so-called learned professions, and other forms of productive endeavor. Commerce, trade, merchants in the English common law system were, as well as the social system, were regarded as, on a commercial level, oriented toward profit, the productive activities of life that were going to result in a material return for those efforts. They were also, surprisingly, on a social level, regarded as somewhat, perhaps more base a motivation because of its commercial nature than was ascribed to those that were called the learned professions, which at that time were predominantly the church, medicine, and the practice of law. In fact, we still find vestiges of this differentiation between what I'll call commercial avocations and professions in our current law. Chapter 75, 1.1, most of you who practice in that area know, contains an exemption from the definition of commerce for learned professions. And thus, statutorily, those activities engaged in the course of practice of law or practice of medicine will not subject you to the treble liability and attorney's fees exposure that results when other folks who are engaged in trying to make a living might engage in similar behavior as yourself. So it is not unusual, if you will, in fact it's historical antecedents, to perceive some type of relationship between the practice of a profession and the level of motivation ascribed to it for the pursuit of profit, pursuit of material gain. In fact, this comes as much as anything if you think about just the very idea of professions. What do professions profess? The source of that usage, with a little trusty work with my dictionary, I discovered, was that most of the professions were distinguished because they had to publicly adopt, as one of their last rites of initiation into the guild, if you will, under oath or other sanction, a set of agreed-upon values and beliefs. That act of profession is why we practice a profession today. This owes as a sort of a source of obligation, as a distinct from the pursuit of commercial gain. That is, instead of being motivated primarily to make a living through the production of profit, you were expected to, through this oath, to have that as a source of obligation, to sort of elevate or re-inspire you to what is a more aspirational form of approaching to life. And indeed, as I recall, Judge Orr in his early speech, I think in 3 or 4 instances, talked about what we as lawyers and I assume other professionals aspire to. It is that aspirational nature that was considered distinctive and continues to be in today's literature distinctive to differentiate what professionals are supposed to find as motivating them in connection with provision of services to the public. Indeed, I think it's still reflected in the fact that in England, instead of being admitted to the bar, one is called to the bar, much as one has heard in times that one is called to a faith. Now, this perception of the historic antecedents and why and how we came to be characterize ourselves as professionals based on this morality of aspiration as distinct of morality of materialism has obviously both been disputed as to whether it ever really existed. Anyone who's read any literature knows that even Dickens would joke about the perception of members who were not the profession of the profession's self-ascribed values and motivations. Also, there's a great deal of literature that it deals with the question of whether the public perception of attorneys has ever been anything but negative, and I will spare you what most of us have heard it, repeated CLEs with regard to killing all lawyers and other quotes from various writers through our culture's literature. But there's no dispute, I don't believe, among anybody who's practiced the tender years that I have, or even more as some of these other attorneys have, that the commercialization of the practice of law is a much more of a reality today than when we started at the practice. You can talk about what the causes of that may be. Some would refer to it as a response, a reactive to some of the decisions that have been made in the areas of the jurisprudence itself. Among those would be the self-regulation constructs or concepts that we saw through the years erode under challenges under the First Amendment and the antitrust laws that eliminated fee schedules, permitted lawyer advertising, constrained the powers of the state to regulate lawyers' conduct in a number of different contexts. Similarly, we have seen during that period the increase in the emphasis on the billable hour, the adoption of more commercial practices in just the management of one's practice, whether it's the growth of the mega firms and large regional firms, the increased numbers of practitioners. I graduated and was admitted to North Carolina Bar in 1977 at number 7699, and an unscientific query went down the hall this morning before coming over and asked the youngest attorney who had just joined us her new bar number, and it was 32,790 for something north of a 400% increase since I've started the practice of law. Now, the same type of factors in the consolidation of client industries. When Wachovia and First Union became Wachovia again, that which was simply a reflection which has occurred in a number of different industries, not just financial services, but a number of different industries that have eliminated clients with the obvious commercial or profit context in terms of available clients for all these additional lawyers to represent. But the effect of the commercialization is one that we primarily think of because of how it affects our daily practice as lawyers. We tend to sometimes forget the impact that it might have, or most certainly does have, on the public's perception of lawyers. And that is in many respects, I think, the essence of Judge Orr's comments with respect to how civility and that manifestation of professionalism, a higher calling, is intended to promote public regard, not only for the courts, but for the individuals who, in the performance of their service, are the manifestations of our legal system, who are the ambassadors, if you will, that will present and be what the public perceives as the embodiment of our values. The changing in the emphasis of law toward commercialization, I believe, has had a significant effect, as had these decisions that have restrained and confined the ability of the bar to, in its self-regulation role, has, I believe, changed the manner in which the public perceives lawyers. In the past, I believe that when there was a greater emphasis on the aspirational characteristics of the members of our profession, there were individuals who sought out attorneys, clients who sought out attorneys, seeking guidance and advice, not necessarily liberty only, or not necessarily escape from liability, but truly moral guidance and suggestions of how to find their way through a difficult time. I think increasingly, as we become what the literature characterizes as less of a morality of aspiration, as the bar has been regarded or adopted, whichever it may be, as a morality of rules or duties, i.e., if I'm an ethical lawyer, therefore I'm a professional. Some of the literature would suggest that's not the case. At least there are folks that argue that that's not the case, that ethics is not just about, or more accurately, professionalism is a good deal more than simply not being unethical. And as a consequence, that we have to hold ourselves out to this higher duty, we have to make that or embody that in our client relations, as well as the relations with the court and other practitioners, and to resist this increasing trend toward commercialization. And the trend is not going to stop. Indeed, one of the articles that I read, and I mentioned just briefly, quite interesting, was about the impact on technology changes on the concept of the billable hour and the construct that has governed many large law firms for the last 15 or 20 years. Because it's the ability to reproduce and access information at a much more rapid pace occurs, the ability to charge a value corresponding to the value of that intellectual property that's embodied in that work product is diminishing. If it only takes a few minutes to run the computer search that used to take 6 hours, it's just not going to produce the revenue. Even if the product, from the standpoint of a client's perspective, if it's not measured on sweat performed, but on the impact of the value of the knowledge it embodies, would not have changed as significantly. With this increased pressure, geographically and socially, have come corresponding changes in the way clients regard us. Clients, I think, less and less, as I said, look to us as advisors and people who might provide a way of guidance, and more as just a service purveyor. And of course, that's going to mean that you're going to be analogized to other providers of service in the marketplace. As a result, there's a increased perception among clients that they have an expectation to achieve a certain result. That's why they hire you. They have a real expectation about how much it should cost, without regard to how realistic that expectation might be. And, pardon me, and they have sometimes a little appreciation for how realistic whatever their assessment of the value or the results may be. It's also the case that these changes in the manner in which lawyers are regulated has also expanded the pool of clients. We now have, I think in a way that we did not have nearly as much when I first started practicing, a much more evolved and developed body of law for consumers and consumer protection. We also have a much more, with the number of attorneys and the number of clients, people in a more consumer-type context approaching lawyers for services. No longer is it just the banks or the insurance companies or the seriously injured, but in many instances it's people who are exposed or involved with very basic legal questions involving family, traffic, small criminal matters, and as a consequence of this, if you will, using the terms of commerce, market penetration, as the expanded pool of folks who are looking for providers of legal services has occurred, the number of people with sophistication or familiarity has correspondingly diminished. We haven't increased our knowledge as much of effective use of legal services, as we have expanded the pool of folks who's going to use them. Now, as a result of this combination of factors, at least those of us here in Wake County who've been engaged in mediating and sometimes arbitrating fee disputes have, I think, encountered a couple of just statistical facts. One is that the trend of disputes is definitely on the increase. You've got a consuming public that's used to getting what or their expectations met, and if a service provider doesn't meet them, they're used to demanding a refund. And it's, I think, reflected in the fact that statistically, as the word has gone out about the availability of our services, that the usage of those services has increased. In 2001, we had only 41 new petitions filed, 78 in 2002, 90 in 2003, and through the third quarter, we had 74, so we're on track for 100 new petitions annually, and that's increasing at roughly, just without having done the math, about 33 to 25%, somewhere in that range annually. Fee disputes are overwhelmingly brought by individuals, and that 3 years, 3 quarters that I used to just provide you this statistical information, only 5 involve petitions by business entities. The entire balance for the entire almost 4 years were represented by claims by individuals. Third, the greatest number by far and the greatest rate of increase are attributable to engagements of a type, of a substantive area of practice law that's more likely to be of consumers, of a consumer nature. This certainly includes domestic law, it includes criminal, mostly traffic matters, and smaller misdemeanor crimes. Now this is, I want to emphasize, this is a volumetric measure. I mean, it's just counting petitions. It's not about, if you will, intensity, dollars amount involved, much less the emotional or disruption that can be associated with some of the other practice areas. And I think it's not surprising when you consider that they are involved with folks who are typically less familiar with using legal services, often in an emotionally difficult circumstance, which is going to lead them to probably have unrealistic expectations, and limited, if any, understanding of what the trade-off is between the costs of seeking a particular outcome and the likelihood of achieving that outcome. But with that combination of a lack of familiarity with the legal market, if you will, or the provision of legal services, and with that absence of reasonable expectations in terms of what the results, I'd suggest to you that the Code of Professionalism that was already described has a couple of points that might provide you some guidance on a day-to-day basis, how to try to deflect or avoid some of these problems. Specifically, I wanted to emphasize that this is unabashedly the adoption, if you read just the second paragraph of what professionalism encompasses, it's unabashedly adoption of an aspirational morality. Specifically, professionalism encompasses a dedication to excellence in serving clients, a respect for the rule of law, the court and other lawyers, and a commitment to seek a just result in all matters undertaken for clients. The practice of law the practice of law is a profession and not a business. A lawyer need not sacrifice the opportunity to prosper, but the practice of law must be motivated by service rather than inspired by profits. As a lawyer, I've subscribed to the following creed. This overarching motivated by service rather than inspired by profit obviously runs right into the obligations we have as individuals to our families and our partners and associates to make a living. But it's nevertheless clearly an encouragement, if you will, a calling to the members of the Wake County Bar to adopt a more aspirational approach in dealing with your clients. And if you think about it, there's probably no one more suited for that than the individual who's approached you, is that an individual attorney who's trying to provide counsel and guidance to that client. As a practical matter, if you adopt a morality of duties, and I'm using these not so much as necessarily endorsing them, but as a shorthand, the idea of client service, you're obviously inherently in a conflict situation the moment you're starting to talk with the client about the fee. That's not necessarily where your interests are aligned. If, in the context of providing services, you could take these parts of the creed and look, there are three that are associated with, if you will, the temptation of materialism and trying to resist those temptations. And I think that it's encouraging the individual attorneys to take into account that they are more familiar with the system. They do have a better idea of the probabilities of outcome than their client, and they do have a better idea about what's a reasonable cost. And if you have the attorney exercising that role and understanding that notwithstanding you're in a conflict situation where you want more of what the client would like to give you less of, if you nevertheless understand the aspirational role and the idea that if you can suspend your personal needs long enough to consider what I would basically say is nothing more than sort of a paraphrased golden rule of placing yourself as best you can into the client's shoes, and to try and consider in connection with that the responsibility of trying to A, shape the client's expectations about what is and is not realistic, and B, educate the client aggressively about what it's going to cost with those expectations that they might initially have. Obviously, these are not easy tasks. At least in my experience, the last thing I typically want to do is lecture a potential client. I much rather convince them that they want to become an existing client of the firm. But nevertheless, it is clearly among the creed's directives or urgings that we consider what role we as attorneys play when we are adverse, if you will, to our client, in trying to educate them about how professionalism will constrain not only what we can do with others. An example of that is the first creed. My word is my bond, integrity is an absolute, fairness and civility are essential, financial considerations will never override my professional responsibility. To tell a client, no, you won't do something, for example, circulate an order. We have an ethical rule. You can't, if the local practice is you circulated orders before submitting to the judge, you are expected to do that. What if it's not a local rule? There's another tenet down here about fairness to your other members of the profession, other people who are standing in the bar. It's not a local practice. Is the duty of zealous to the client, or is there any downside for circulating the proposed order in advance to opposing counsel? Financial considerations will never overrule your professional responsibility. Seems to be straightforward. Clients should not expect to be able to pay you to engage in behavior you wouldn't feel comfortable engaging in if you were working pro bono. Maybe work harder, maybe work longer, but engaging in a different type of behavior, adopting a different kind of conduct is simply not consistent with this urging, if you will, of this element of the creed. The other two, the second, the commitment, refers to loyalty and competence. We'll focus only on the next to last sentence, where among the promises that you make to my clients is I'll be worthy of your trust by providing vigorous advocacy, independent guidance, reasoned counseling, and fair value in services performed. Fair value in services performed allows a relatively straightforward encouragement for you as the attorney to consider what is the fair value, what is the reasonable expectations of your clients, and try as best you can in those difficult cases to make them see that in a more enlightened way what is a realistic expectation, and for us to understand, tell them what it's going to cost. Let them truly understand, and if it changes in the course of the representation, it might be better than to send a letter or a memo that you either call them or call them in. And I realize, I personally don't have a practice, and I don't mean to suggest that folks that are not sympathetic to people that deal with a sheer number of clients far in excess of me by virtue of the type of law they practice. But nevertheless, I would submit to them that they will spend more time dealing with a fee dispute, going through the mediation process, potentially the arbitration process, and possibly lawsuits, because a number of our fee disputes will sometimes be associated with or grow into ethical complaints, than it will take to spend a few minutes with them or send them a letter pointing out to them that whatever their expectation of cost was, it's changed because of now some new event or some new goal that has occurred. Similarly, we can look at what the value of the service is that the client's asked for and decide whether we as lawyers, were we the client willing to buy that service. If you as an attorney would not be prepared, if someone was handling your divorce, to spend a certain amount of money to engage in to prepare a separation agreement or something of that type that no one may ever sign and charge quite a bit of money for it, you might want to consider whether that's something you should routinely do with your clients. You are much more knowledgeable than these members of the public with regard to what is a fair value. And this creed urges you to take that into account when provision of services and try as best as possible to avoid having a client convince you to do something which you believe, I mean, it's ethical and it's lawful, but is simply not going to result in a fair fee because it's likely to be a wasted endeavor. The client obviously has to choose, but you have a role as the attorney, as an educator, to convince them of the error of their ways. The final provision of the code in my closing remarks would be associated with the pledge to opposing parties and their counsel. Among other things, it promises to pursue the most efficient and least costly solution to problems and avoid unnecessary delay. Now, I realize that this is a pledge that's made to your adversaries. But I will suggest from my experience in the years, and I know that I see some other members of the fee resolution or fee dispute committee who would indicate to you that that is also something that clients would like to hear pledged to them. Often associated with the client's lack of understanding of what the time demands are on any attorney. But nevertheless, this pursuit of efficient and least costly solutions and the avoidance of delay would be good advice to consider not only pledging to other attorneys, that is, you're not going to increase the cost of the file to obtain an advantage, but likewise to your clients that you're not going to increase the cost of the file to obtain a higher fee. All of these guidances, all of these commitments, these pledges that are associated with the Code of Professionalism ultimately are intended to be sure that the public has a higher regard for the members of our profession and that they believe that we are truly called to the profession and that we carry a set of aspirational goals that are not as limited as those that might appear in the most public perception of lawyers as, you know, the proverbial throw the quarter in the car. We either will or will not, through our behavior and with our individual clients, live up to the final, the overarching directive of this creed of whether we will end up being motivated by service or inspired by profit. Thank you.
And thank you very much, Joe, for your insightful comments on fee dispute resolution, incorporating our creed into your remarks. That brings us to our fourth speaker today, Dean Gene R. Nichol, who is the Dean and Burton Craig Professor at UNC Law School, where he teaches courses in constitutional law and civil rights. Most of you know that he came to us after having served as Dean at the University of Colorado. He has published articles on civil liberties and federal judicial power in a wide variety of law review and professional journals. He has also written as the op-ed editor or one of the op-ed writers for the News and Observer. He's worked extensively throughout his lifetime in public affairs, has been elected to membership in the American Law Institute and American Bar Foundation Fellows. He went to the Oklahoma State University, where he played football and graduated from the law school at the University of Texas. Dean Nichol.
Thanks. Yeah, I'm delighted to be here, and I appreciate that kind introduction. I did go to Oklahoma State University. Someone introduced me last week and indicated that it's only because I'd grown up in Mesquite, Texas, that I could have regarded Oklahoma State University as an institution of higher learning. So I appreciate you not going down that route. Well, we'll hear something about that later. I'm delighted to be here for a variety of reasons, one of which, or I guess the largest of which, is I'd like to salute the Wake County Bar on this program, on these professionalism efforts. I am a modest student of these questions. Feel like that in law schools and in the bar, we do only the most inadequate of jobs in addressing them, and we all have a lot to learn, so I think this is a great set of discussions. I appreciated Joe's talk. I am sorry to have missed Roger's. I love to listen to Roger talk, and a number of you indicated how strong it was. Roger and Wade, both of them make me swoon like a teenager, so I would like to have heard that, and I would like to have heard all of Justice Orr's comments, which sounded at the very end to me to be spirited, which is what I would come to expect. I only caught the last minute or so, and I'm not an expert on the Gale business. I heard some objection about a UNC law professor, which I didn't quite catch. I think it was a reference to my good friend and colleague, Rich Rosen, and so I quickly looked down my teaching schedule this semester and saw that both Rich Rosen and Bob Orr are teaching at the University of North Carolina, and I thought, what a marvelously diverse institution that we have. I'm also glad to be here this week as the only person in North America who successfully predicted the outcome of the University of North Carolina-Miami football game. And up in Chapel Hill, we only get 1 or 2 weeks a year that it's safe to talk about football, so I wanted to mention that. It's also, I don't know if you noticed this, it's election day today, as far as I understand, so I assume a good number of you are going to go home and vote your conscience. What I wish is that I could talk you into voting my conscience, but I suppose that's not apt to work. Professionalism in a broad sense, in a philosophical sense. Well, I won't talk about it in a philosophical sense because though I was a philosophy major in college, I'm not philosophical by bent. But there are a couple things I want to explore with you. Professionalism discussions, it seems to me, ought always to start with Dean Pound's description of the legal profession, the practice of a learned art, in the spirit of public service. We all spend a lot of time on the first of those, crafting our efforts to serve our clients into a learned art, what Albert Coates used to call mental character, training a mind that refuses to do a sloppy piece of work. That's a lifelong operation, and I certainly learned a whole lot more about it in the practice of law than I did when I was in law school, but I think that's as it should be. We're all going to be lawyers a lot longer than we were law students. But the second side of that phrase, the other side of the coin, the spirit of public service, that's what we're discussing today, this afternoon, this side of professional obligation. In the spirit of public service. What does that mean? Well, we all have our answers, and likely no two of us would answer in exactly the same way about this notion of the spirit of public service. And at least here in Wake County, it's perhaps widely known that what I have to say is not exactly a recognized formula for consensus. The News and Observer, I now see, feels compelled to publish full-page editions of letters to the editor explaining just how full of shit I am. But I want to have a go at this question, nevertheless. I think, after all, that this is what I was invited here for. At the least, I would guess that in the spirit of public service suggests a cast of mind, an attitude, a perspective, suggesting that we don't only stand in the shoes of our clients, doing whatever it is that they would have us do, we also have a separate obligation, a public one, to our colleagues, to our court system, to the justice system as a whole, perhaps even to the broader society. There are steps that we won't take. There are acts that we won't embrace. There are practices that we won't engage in, even if they might appear to be in the narrow interest of our clients. We might argue and squabble about what those are, or how broad that set of limitations might be. What are the characteristics of our public obligations? What are the limits we recognize on private interest and on advocacy? But the point remains, we will sometimes be guided by the public's interest rather than our client's interests or our own. So, what are those obligations of public character, public service? One I'm going to mention, but I'm not going to burden you with it for long, because I know it'll try your patience. And you didn't come here to be preached at by some flake from Chapel Hill. But I talk about this all over the country, and I can't ignore it completely at home. We carve equal justice on our courthouse walls. It is the cornerstone of our system of adjudication. We swear fealty to it every day, each of us. For decades, we've announced as a fundamental principle of our Constitution that there can be no equal justice, where the kind of trial a person gets depends upon how much money he has. But what we actually do has little in common with what we say. Over 80% of the legal need of the poor and near poor in North Carolina is presently unmet. The Legal Services Planning Commission study, recently completed, shows dramatic unmet need in poor, Black, Latino, elderly, rural, and disability communities in North Carolina. And that underrepresentation relates to matters central to the core of life, like family law, domestic violence, housing, unemployment, social services, and finance. In the bar, in the courts, in the law schools of North Carolina, we embrace equal access and equality generally, rhetorically, without making serious efforts to give them practical content. Ordinary citizens are priced out of the system of justice, and they are barred from participating in the closed regulatory scheme that excludes them. And that poses a powerful tension with our aspirations to equal justice in every city, in every county, in every state in this nation. It's my strong sense as well that those, many of us, who think that we can be agnostic about this exclusion, deeming the marginalization of so many from the effective operation of the legal system as a public issue, perhaps, or maybe a legislative issue, or maybe the court's issue, but not a lawyer's issue. I've heard it put this way: when my pipes are clogged up, no plumber's going to come to my house for free just because I can't afford him. I feel certain that that widely shared view in this profession is wrong. First, and I guess most obviously, it's wrong because it's at odds with what we say. It's at odds with our declaration of a commitment to, quote, a spirit of public service. It's at odds with the aspirational standards of the American Bar Association, committing to pro bono service. It's frequently at odds with the oaths we take to practice law. And it is at odds with the language of the Wake County Bar Association's Creed of Professionalism, which states the practice of law must be motivated by service rather than inspired by profit, and that financial considerations shall never override professional responsibilities, and that we commit to make our legal system more accessible and more responsible and more effective for all. So we profess commitments that the plumbers and the realtors and the doctors deny. And there's more than that, of course. In my judgment, We can't both cling to our status as a self-regulated monopoly, which we are, and be agnostic about whether huge segments of our society are priced out, fenced out of the voluntary use of the civil justice system. We do make choices in this regard. We enforce rules against the unauthorized practice of law. We punish those who would compete against us without sanction. We set the terms of training and responsibility and cooperation and liability in practice, which may have dramatic effects on the cost of legal representation. We decide to offer subsidized support for some kinds of representation and not for others. And maybe most importantly, faced with a legal system that excludes effective participation by so many, it seems to me that we could sensibly do one of two things. We could either make access to lawyers far more pervasive, or we could radically simplify the operation of the legal system in an array of areas so that representation by lawyers is not necessary. We have chosen to do neither. It's a choice. So I believe that these questions of access to justice are core matters of our ethical obligations. And in the courts and in the bar and in the law schools, they need to take a dramatically more elevated place in our discussions, in our standards of practice, in our constitutional law, in our everyday lives as professionals. As Lord Brougham wrote a century ago, it was the boast of Augustus that he found Rome brick and left it marble, a praise not unworthy of a great prince. But how much nobler would the sovereign's boast be when he shall say that he found law dear and left it cheap, found it a sealed book and left it a living letter, found it the patrimony of the rich, left it the inheritance of the poor, found it the two-edged sword of craft and oppression, and left it the staff of honesty and the shield of innocence. But I'll stop there before you get grumpy. What of this other matter? The notion of professionalism, so defined. The idea that we surely believe in here strongly. Otherwise, by definition, you wouldn't be here. But an idea, too, that we have a tougher time getting our arms around, defining. It's the notion that merely failing to violate the canons of ethics, our codes of responsibility, isn't enough. We don't meet the high standards of professionalism by avoiding disbarment. You can stay out of jail and still not be Atticus Finch. How to start? How to talk about that? It's a complicated time to be a lawyer. You may not know this, but we're not praised in every quarter. Even before this week, we weren't praised in every quarter. There are lawyer jokes galore. I've been a dean for 15 years, and that means apparently people feel some near religious compulsion to come tell me the latest lawyer joke. I've got a remarkable collection. They'll walk right up to me on the 16th Street Mall and tell me the latest lawyer joke. Usually right before taking me aside to say, by the way, is there any chance my boy could get into law school? It's always my boy, by the way. But this is a capacious profession. Everything under the sun goes on in the name of lawyering. And it's a controverted one, a contested one as well. Our course as lawyers won't any longer, I think, be set for us. We'll all have to choose our path. Some see our work as the crassest of commerce, pushing high volume and an even higher bottom line, while others see the work of lawyering as tapping the highest aspirations of mankind: service, duty, honor, integrity under fire. I try to tell our students over and over again that after almost 3 decades in this profession, I don't see our role reflected in those lousy ads on TV or in the practices of those who would equate the habits of lawyering with those of the World Wrestling Federation or the Jerry Springer Show. And I know it's hokey, but I choose to tell them that I see our our guideposts through a different lens. I see them through the work of Thomas More, crafting and living out our mandates to religious liberty, or in the work of a 32-year-old lawyer, Thomas Jefferson, writing a literal brief for his nation in the Declaration of Independence, or in the work of our greatest lawyer and greatest legal writer, Abraham Lincoln, rededicating a war-torn nation in Gettysburg, or in Thurgood Marshall, crisscrossing the country with a courageous and studied plan to end our regime of legally sanctioned apartheid, or in the efforts of Ruth Ginsburg, honing in case after case the tools to strike back at a mandated second-class citizenship for women in America, or of our own Julius Chambers, who in the face of burnings and bombings called us back to our foundational promises as a people, or in Frank Graham, charging us to build a nobler and fresher civilization in this ancient commonwealth. I have 3 daughters, and when they were real young, I loved to read to them from The Little Prince. One of my favorite lines was, "The most important things in life are the invisible ones." That, I think, is the tough work of understanding and supporting and teaching about professionalism. In legal education, we know how to teach contracts and property and torts and constitutional law. We even know now a little better how to teach skills and ethical codes and to work through clinics and supervised practice and externships. But professionalism, the highest aspirations of lawyering, the tough demands of character, integrity, courage, selflessness, independence, the difference between most folks and lawyers like Ralph Stockton and Burley Mitchell and Jim Exum and Betty Quick and Julius Chambers and Jim Ferguson and Ozzie Askew and Jim Maxwell and Burton Craig and Hank Van Hoy. That's a tougher matter. The difference is not just skill, though that's a lot of it. It's also, in the Little Prince's words, the invisible things, the most important things. One way, of course, to talk about those crucial matters, the important ones, is to use creeds or guidelines, like you've done in Wake County. Talking about your word as your bond, fairness and civility, loyalty, competence, diligence, good judgment, providing timely information, trustworthiness, independent judgment, vigorous advocacy, respect, candor, and courtesy. And I think these are good markers, strong road signs, good declarations of intent to steady us for troubled times. And of course, to point to afterwards when we've already gone astray. But we know they're also not enough, because as we said, we're looking for more from ourselves than from the mere absence of serious transgression. So sometimes, especially when I'm talking to young lawyers, I try to lay out my hopes for them as well as my fears. What the optimist in me, and there's always a lot of that, particularly on election day, what the optimist in me urges for them. I do it as a way of reminding, or trying to, that with all our codes and our expertise and our standards, we cannot omit the weightiest matters of law: judgment, mercy, and faith. Put another way, as it's been said, compassion without technique can be a mess, but technique without compassion can be a menace. So I'll close with 10 hopes I have for us all. First, I would remind with Lincoln's words, always tell the truth, you won't have so much to remember. Or Twain's, when in doubt, do the right thing. It'll confound your enemies and amaze the rest. Remembering, of course, that this is both a professional and a personal creed. Putting it, as again Lincoln did, resolved to be an honest lawyer And if you can't resolve to be an honest lawyer, then resolve to be honest without being a lawyer, rather than consenting from the outset to become a knave. Second, I hope that young lawyers will see that you cannot have a powerfully developed sense of justice without a powerfully developed sense of injustice. So keep your eyes wide. Keep your wits about you. Actually be a member of the community you're seeking to serve, unadvertised. These days, it's important to emphasize that last phrase. Keep it unadvertised. Third, I hope that young lawyers will come to understand that while the words of appellate opinions and statute books are crucial to the study of what law is, the actual implementation of law more frequently involves questions of power. And far too many are fenced out, priced out, mystified out of the legal system, giving the lie to the most basic claims we make as a profession and as a democracy. And this marginalization, as I've said, implicates us all. Fourth, I hope that young lawyers will have the confidence to believe that they can prosper and serve and excel on the basis of their own preparation and hard work and gradually honed skills. If not this time, then next time and hereafter. That the cheater ultimately thinks little of himself and his enterprise. He sells his own dignity for a decidedly inferior mess of pottage. And that they'll see that though the power of their claims and their causes may vary, their skill and commitment and independence and character and courage will follow from challenge to challenge. They remain the literal stock of this trade. Wasting them away instead of investing and nurturing them with all you have is the worst sort of short-termism, the most careless example of eating your own seed corn. Fifth, and as you think of that, sometimes in my judgment, the best lessons can come from the past, from contemplating those who have gone before. We all have our markers. When I struggle in my own admittedly different line of work, I find it helpful to dwell on folks like Bill Aycock and Bill Friday and Dixon Phillips and Frank Graham. It's daunting and it's depressing because I can't live up, and I know it, to any of those comparisons. But at least it helps to be crystal clear about which direction to look to see the sunrise. Sixth, I hope that young lawyers will remember, and I know this is hard, but I like the aphorism, you make a living by what you get, but you make a life by what you give. I know that that is something of an exaggeration. It is surely true that what we get has a big impact on the life we make. But the point suggests a truth anyway, a truth that I see carried out in the legal profession every day. And it's true regardless of your politics or your ideology or your worldview or your perspective. Whether you see yourself as a creature of the right or the left, corporate or social, combative or congenial, regardless of what picture you draw of the good life, it is essential to cast your lot, to spend yourself in causes larger than yourself. And that is often most effectively done in arenas that don't draw the biggest profits. Seventh, I think it's important to recognize and to concede that all these matters of professional obligation, of duty, of character, of constraint, they all seem to run against a great tide in the rest of modern life. In earlier eras, bound as they frequently were by tradition and hierarchy and family and tribe and, of course, privilege, the sense of what was required, what we owe to each other, was far more concrete. Try to identify them and build upon them. We stand against powerful cross currents and sometimes inexorable broader tides. But that just means that our task includes the lighting of candles. It can't be satisfied with the cursing of darkness. 8, now all lawyers, in my judgment, are called upon to be ministers of justice, apostles of the rule of law. Now, before you roll your eyes, I don't mean this in some highbrow or utopian sense. The world has much changed since September 11th, and we will continue to face challenges to our safety from terror, regardless of who is president and regardless of the politics of the times, challenges that separate our fortunes and our circumstance from much of what life was like before. But we have also, at home and abroad, had glimpses of the abyss. Societies that claim to sacrifice legal regimes for the purported demands of urgency. Even assertions here that citizens could be declared strangers to the Constitution, or that judicial review should be cast aside, or that attorney-client relationships should be discarded and cast away. I always liked Atticus Finch's line in the closing argument in the trial of Tom Watson. I'm no idealist to claim that law is the great leveler, the great equalizer. That to me is a living, working reality. America cannot be America, in other words, without a vibrant and secure legal regime. We cannot live our lives in security or do our business with vigor or produce strong citizens for the next generation without a concrete commitment to the rule of law. Every lawyer, regardless of situation or pedigree, is a testament to these notions, and we may be increasingly called upon to give witness to what we know. 9th, I like, most of all, to say to young lawyers that I wish for them and for their generation that they will lift their sights higher, dream better, lead more, challenge more, change more, protect more of what's sacred to them, live closer to their core and to their ideals than my own generation has managed. I hope they will literally recapture the ethical meaning of professionalism, which includes not just competence and civility and good manners, though all of those things are important, but also the moral contributions that professionals are obliged to make to a complex and a frequently troubled society. Recognizing that the pursuit of happiness and the pursuit of justice can be as one. They march not in opposite directions, but hand in hand. And 10th and finally, I always say to young lawyers that I hope your future skies will be of that perfect, ennobling, untainted, unparalleled Carolina blue, not the darkened, devilish shade seen sometimes just 8 miles up the road in Durham. Thank you very much.
Dean Nichol, thank you for the tremendous capstone to what I believe has been a wonderful, wonderful 2-hour CLE program. I call your attention to the fact that 2 hours credit, but you'll have to pay the $2.25. I think it's $4.50, but you pay that directly to the bar. As we leave here today, I've got to tell you that I'm more proud than ever to say I'm glad I'm a lawyer. Go, thank you, and let's thank all of our panel members for their wonderful presentation.